You take my hand, my time, oh, my, together we will.
David.
Doc. Doc. Doc.
Yeah, can
Hello,
you look
Doc.
at your charts and get ready, please?
Good.
Yeah, can you look at your charts and get ready, please?
Good. Good afternoon, everyone. On behalf of the Ghana chapter of the AI Collective and Knowledge Innovations, I'd like to warmly welcome you to today's webinar under the theme Responsible AI and Data Protection, aligning Ghana's Data Protection Act with emerging AI use cases. Now, just as a roll call, I would like to acknowledge the presence of Mrs. Vanessa Akwete, and Vanessa Kofinti. Also, I'd also like to acknowledge Dr. Arnold Kavapo, kindly notify me if you are online. Toniona Zioche, Desmond Israel, Good. So I'm seeing Tony, I'm seeing Vanessa Apwete, I'm seeing Vanessa Kofinti. Kindly notify me if you are online, Desmond. Good. So I see Desmond. Yeah. Dr. Arnold Kavapo, kindly let me know if you are online so we can begin. Good. All right, so we are good to go. So we gather here today at a genuinely critical moment. Ghana's Data Protection Act 843, which was enacted in 2012, that is nearly a decade before the AI boom, remains primarily the only legal guardrail for what is rapidly becoming an AI-powered economy. And that gap demands urgent and informed conversation. From fintech credit scoring and mobile money data to administration, Ghanaians are already being shaped by algorithmic decisions that our existing legal are really not designed to govern. So today, we want to bring into sharp focus these fault lines: consent and purpose limitation, algorithmic accountability, cross-border data flows, and the ambitious legislative reform agenda that is currently before Ghana's parliament, with the goal of moving us from diagnosis to actionable recommendations. To set the right foundation for that conversation, let's invite Dr. Arnold Kavapo, a distinguished voice at the intersection of law, technology, and public policy in Ghana, to deliver the opening remarks. Doctor, over to you.
Okay, thank you very much. I can also use video, but I can't do it from here. So good day, everyone. It's a great pleasure to be here with you today. Thank you, AI Collective. Thank you, Knowledge Innovations, and thank you, Gen AI Collective Ghana. Let me start it off. Can you hear me?
Doc, we can hear you. We can hear you.
Okay, fantastic, fantastic. Okay, so let me start it off with a quick story. So imagine your child walks into a hospital, a doctor consults an AI system to support a diagnosis. The system draws on vast amounts of data, patterns, histories, probabilities, and produces a recommendation. In that moment, as a parent, you are probably not thinking about data protection laws or algorithms. you are probably thinking about just one thing. Is my child going to be okay? But for me, to trust that system, something deeper must already be in place. Someone must have ensured that the data behind it is lawful, is accurate, and is relevant, that it has been used responsibly, and that there is accountability if something goes wrong. Because without that, something very important begins to slip away quietly, but significantly. We begin to lose our sense of agency as a people. We begin to lose ourselves in that whole interaction. Decisions about us start to be made by systems we do not understand, cannot question, and increasingly cannot challenge. And when that happens, it is not just a technical failure, it is a loss of control over our own lives. And that is why this conversation matters. Artificial intelligence is already shaping decisions across finance, and the moderator mentioned about credit scoring, digital credit, and so on and so forth, which processes millions. I recall in my previous life, we used to iterate something around $4 billion and 4 billion different iterations before we come to even do a disbursement on an individual. So AI is already affecting financial services, healthcare, education, employment, and public services. But as its influence grows, we must be guided. There can be no responsible AI without responsible data governance. AI systems depend on data. And when data is flawed, biased, misused, or unlawfully obtained, the outcomes, no matter how sophisticated, would reflect those weaknesses. Now that brings me to the Data Protection Act. I think the moderator already spoke about the act being in place since 2012. I would also add that actually the version of the act was ready in 2010. It was only in 2012 that the act then became passed. So the act actually precedes the GDPR, which started in 2018. Although, of course, it still borrows extensively from some of the initial parameters under which data protection principles were guided by. But, you know, the Data Protection Act has served us well, and it's probably one of the most futuristic legislations out there at the time, and even till today. The principles of lawfulness, fairness, transparency, purpose limitations, data minimization, accuracy, and accountability still continue to define data protection principles across the globe. And so I'll say that because if AI systems operate without transparency, they will erode trust. And if they operate without accountability, they'll create systemic risks. And if they operate without fairness, they will exclude the very people they are meant to serve. At the Data Protection Commission of Ghana, are positioned to become an enabler of innovation. But that innovation must be anchored on trust. We do not see data protection as a constraint. We see it as a critical infrastructure for the digital economy that is sustainable, inclusive, and globally competitive. Ghana stands at an important moment. We're building a dynamic digital ecosystem powered by mobile money, interoperability, and emerging AI capabilities. Let me add 2 cents to this. I think a lot of times we assume that we are followers when it comes to innovation and technology. But if you look across the world, I think Africa have demonstrated, especially when it comes to mobile money, that we can indeed lead on a number of fronts. Nowhere else in the world have we been able to build such a sophisticated system of mobile money, and so on and so forth. And the same too can also be said when it comes to the payment rails, like our GIPS. We're able to do real-time settlement across every payment channel. That again is a big, big innovation. Tie that in with the fact that Africa has the youngest population, and most of this population is connected somehow to some digital device. You know, we're bringing in digital first generations. And so one, they will continue to become big consumers of data and generators of data. They will also continue to be people they will continue to become a rich market source for any super platform. And because of all of these things, we need to make sure that we are able to protect and ensure that that digital sovereignty that we require as a nation is protected. So we are a country where millions of citizens already transact, borrow, save, and interact digitally every day, generating one of the richest streams of real-time behavioral data on the continent. If governed well, this becomes a foundation for inclusive innovation. If governed poorly, it becomes a source of systemic risks and erosion of trust. Let me end here where I began. One day, your child and millions of Ghanaians will rely on systems powered by data and AI to make decisions that affect their lives. When that moment comes, they will not ask how advanced those systems are. They will ask a simpler question: can we trust them? If we get this right, we will not just build intelligent systems, we will preserve human agency. And I continue to underline that word: human agency. Protect dignity and build a digital future that we can truly trust. Thank you very much for having me today. And then I'll be here to continue with the discussions. Thanks, everyone.
Thank you, Doctor. That was a very riveting and compelling opening there. So the key word for me is human agency. AI is supposed to advance human agency and not curtail it. So we move on to the next section of the event. We have our speakers, and permit me to give a little introduction here. So we have Vanessa Kofi-Nti, who is a Ghanaian tech lawyer specializing in fintech, digital assets, and tech policy. We also have Desmond Israel, who is a lawyer with over 15 years of experience in legal, ethical, and social implications of AI. We have Vanessa Akwete, who is an associate at 8Geeks at Law, heading the Artificial Intelligence Desk. And we also have with us Tony Onazi Uche, who is also a dedicated and seasoned research expert in labor and data rights, international security, and conflict. Welcome, ladies and gentlemen, to this segment of the conversation. So to start it off, our aim this evening is basically to explore how we can advance responsible AI innovation while protecting privacy, trust, and compliance in Ghana's digital ecosystem. So let's start off with Madam Vanessa Kofi-Nti. Data protection laws and AI innovation. How exactly do we go about striking the right balance between the two?
All right, thank you, David. Hi, everyone. So I was a bit concerned how you might phrase that. I think this topic always comes up in these type of conversations, and it's usually positioned as an either or like an antagonistic debate. But a better way to look at it is how to strike the balance, like you just said. When Mr. Arnold was giving his introductory presentation, he mentioned that AI is something that's already with us now. And yes, Ghana is leapfrogging because the innovation always outpaces legislation, at least with present technologies. And so it's not a bad thing that we are playing catch up. I think an important approach is to look at it from how to contextualize regulation. And so if you're looking at AI regulation, how do you contextualize creating a framework around the technology for the current place you are in? And it's important to note that you're not looking at it from the angle of just Ghana, but regionally, right? Because not only is Ghana leapfrogging, most African countries are playing catch up. And it's important to look at it from that context. Okay, so if we are going to create a framework to regulate AI, how are we looking at it in terms of our Ghanaian specific use cases? How are we looking at it regionally? There are so many projections in the new strategy about, cross-border data flows, etc. So obviously, if you're going to be creating a framework for AI and you are trying to strike a balance, you are looking at it from that wider angle, right? And obviously not to also blindly copy existing frameworks without understanding what I guess the exact use that you as a country can benefit from AI frameworks and your data sets, etc. So are you looking at a risk-based approach? Are you creating like a flat regulation that no matter the type of products that the person has, there's just like a flat rule, which in my opinion is why usually frameworks work, especially risk-based frameworks. And so if you are looking to regulate the type of data the person is using or what they're going to use the data for, and the risk involved should determine the type of category or whatever stringent rules would apply. I think I've been speaking for a while, but essentially, like you said, data protection, AI governance is not should never be seen as something that is opposing innovation. Innovation is good, yes, it's going to help us grow. There are very wild projections again in the strategy, which is not unfounded as to whether we'll be able to achieve it. That's a different conversation. But it is real that AI can lead us to very real monetary, growth projections, etc. But it must be done side by side with regulation that allows innovation to run concurrently, essentially. And then we fine-tune it as we go. I mean, the EU came out, very hard, very fast, and there are so many critiques of their existing framework. What we also can't do is go by the no legislation approach, because that would definitely not work for us. And the goal is to just find the balance. So you're protecting people, you're protecting people's data, like Arnold said, you're protecting people's sovereignty, their autonomy. That's how you reach your balance. Thanks.
Thank you very much, Ms. Kofinti. So now we move on to Ms. Akwete. Could you kindly tell us what gaps exist between current data protection provisions and emerging AI use cases? For example, generative AI, biometric systems, predictive analytics. And how can these gaps be addressed through policy or regulatory updates?
Hi, David. Thank you very much for that question. And hello to everyone. Thank you for joining us. I just want to start off by saying the Data Protection Act we have right now is a fantastic piece of legislation. I think when it comes to conversations like these, we can not recognize how well laid the legal foundation we have is. If any of you have ever been with me in a conversation about regulation and AI, my stance is that we need to take a very soft approach to regulation in order not to stifle innovation like we've mentioned, But the reason I believe we can take that approach is because we sort of have the foundation already to allow us to protect against the very basic harms. So I will start off by telling you the fantastic things that the Data Protection Act does, and then I will move on to some gaps that we've identified, or rather, in my opinion, things that I feel can do with a little more revision or strengthening. But at its base, the Data Protection Act does a really good job of protecting data across board. So when it comes to strengths, the Data Protection Act has certain principles. Like Arnold said, it drew from certain general universal principles when it comes to data protection. So when you look at things like the principle of minimization, which says that you have to use data in a way that's not excessive, it needs to be used in a way that is necessary and not excessive to sort of encroach on rights. We have that enshrined in our Data Protection Act. When you look at things like the principle of limitation, and what that says is you have to collect data for a very specific and lawful purpose. It has to be related to the activities that you are carrying out and not just sort of random and arbitrary. That is also enshrined in the Data Protection Act. When you talk about the principles of transparency, which are so important when it comes to AI, you have to make people aware of what their data is being used for. Our Act has provisions that cover that. Our Act is also very protective of data subjects. It recognizes that ultimately the data belongs to the data subjects. The data subject is the owner, and they have the right to determine and control how their data is processed. Sorry. We also have provisions around automatic decision making, which is a big concern when it comes to AI and these systems, because AI systems can be trained in a way that they inherit bias and they can sort of start to apply the bias in those decisions that they make. So our Data Protection Act has provisions to guide against us, make sure that there's a human in the loop who is ensuring that those decisions aren't biased or don't affect people in negative ways. So like I said before, it's perfectly normal that our act doesn't cover all the harms that AI has come up with. If you really look at it, AI sort of blew up. AI has been around for a long time, but AI sort of blew up in 2023 with ChatGPT. But like Arnold mentioned earlier, our act has been in place since 2012. So it's just the way things go. The technology will come in place, society will evolve, and then we sort of have to put the revisions in place to catch up. So with that background, I just want to point out a few things that I feel can be improved to deal with the risk of generative AI and all this, all of the unique gaps that we are seeing come up in the space. Firstly, our Data Protection Act is very limited to personal data. So when you read through it, you see that it's at its core, it's an act that protects privacy first and foremost, and it really focuses on the information that can be used to identify individuals. When we are talking about AI, I think a little bit has to be done in terms of broadening that scope so that we are covering non-personal data as well, because a lot of the things that are relevant to generative AI have to do with the non-personal information, like the images, the voices, all of that non-structured data, which I don't think our Act at this stage tackles quite in depth. When it comes to, there are certain provisions in the Act now that, again, because of the time that it was passed, they did a fantastic job of dealing with the gaps then, but right now they have sort of become avenues which can be exploited when you view them from the lens of generative AI and AI as a whole. So our Act at this moment has provisions which allow for the collection of personal data from public records. The whole concern with generative AI and AI as a whole right now is people feel like their information may be used without their consent. When you look at provisions which allow collection of information from public records, a big thing that happens when you use these AI system or when you're training them is that information is scraped off the internet, which is a public resource. So with the wording of that exemption, you realize that we've created a little bit of room where people can sort of maneuver around and evade collecting consents from data subjects because they can just rely on this public records exemption. Another thing that we are seeing is being interpreted in a way that it wasn't quite meant to be, is the allowances around further processing. So how the Act is built now is that you have specific rules under which you can collect data, if that's consent or if it's under a contract or if it's under a statutory duty. But once you have that information, if there are certain uses that are incidental to the reason you collected it for, I simplify, but you can then process it for additional purposes. That I've noticed is the sort of exemption that people who are using people's information to train AI systems are going under, claiming that they collected it for a certain purpose, but are processing it further, and by processing further, using it to train their AI systems or deliver AI-enabled services, because this is a further processing activity. So I think there's a lot of work that can be done in that arena, just to tighten up the wording to make it fit the AI uses more, or put in place the roadblocks or the measures so that those uses aren't exploited or the use doesn't become excessive in a way that harms the data subjects. And the third thing I wanted to raise is, just because you did mention, I believe, biometrics and just predictive analysis, our Act sort of doesn't raise provisions around how biometrics can be used. Biometrics now, and again, in 2012, you have to view it from that lens. Things like this weren't really important. But now we live in a day and age where you can sort of collect someone's fingerprints from their phone, or you can scan their face when they're signing up for an app. You can do a liveness check. So biometrics have become a very important part of what we should consider personal data or data that you use to identify individuals. Our Act doesn't currently have the provisions to sort of protect that set of information, and I think it's something that can be looked at as we revise the Act. In terms of closing the gaps, I don't know if it might be a little controversial, but I wouldn't say I would put out specific rules for closing these gaps just yet. And it's because I think we have a long way to go when it comes to actually understanding how these systems work. What I will say is, I can sort of share my broad thoughts around the approach we should take towards closing these gaps, as opposed to specific clauses that need to be put in the Act. The reason being, I think we need to be very careful when we revise these laws. Like I said, we need to take a softer approach. It's very easy to say, yes, they're in place. Yes, they are sort of negative uses, and so we need to clamp down on those. But especially because of where we stand as Africans, you need to realize that we are not in the same shoes as people like who are in the EU or people in more developed nations. Like when you go to the EU, the US, AI is sort of it is an addition. So it's helping us do things maybe in a quicker way or a more convenient way. Whereas when you come to Africa, using the health example Arnold raised earlier in his submission, for us in Africa, getting access to that health app might be the difference between life and death. It's not just, oh, I don't want to leave my house, so I want to use this AI tool to do a quick diagnosis. People just don't have access to hospitals or any of that infrastructure. So for us, we need to not be as strict in our approach to regulating. So I'm not a big fan of hard regulation like the EU AI Act. I think my proposals for closing the gap with policy is we need to take a very flexible approach. Very recently, we are involved in the legislative review exercise that's going on. And when you speak to stakeholders and you engage with industry, you come to realize that there's a lot of advantages to taking a more flexible approach to legislation and policy making. So I think we need to be very keen on collaborating with the developers and the people in the industry. You should be willing to learn, take feedback, and adjust our legislation to suit our local context. I also think we need to be very keen on applying a principle of proportionality. So we don't set, I think that we shouldn't set hard, fast rules. It's not a one size fits all. I think we need to be open to graduated schemes where, as necessary, we trigger additional compliance, but not start with a hard rule for compliance that not all developers or deployers at their different stages can meet. And lastly, I think we just need to be very practical in our approach. Feasibility is a big thing for me. When you work in a space like I do, and you interface with both the regulators and the companies on the other side, you tend to see where certain gaps fall in terms of not being putting regulation in place that doesn't really translate in a way that helps the system grow. So we need to be very careful about the concepts that we put in place and the rules that we are asking to entrench in these laws, not just in Ghana, but globally. So to give a specific example, when we talk about like the right to deletion or the right of erasure for which we have in our Data Protection Act right now, we need to ask ourselves, in this day and age, is that feasible? If someone says, okay, remove me from the system, like absolutely rub every trace of me from the internet, is that practically something that we can do? So I just want us to be minded about those provisions as we go through the revision exercise and putting in place policy. Let's make sure that the rules that we codify are actually relevant to our context and they are enabling and not stifling.
Thank you very much, Madam Akwete. That was a detailed and insightful response. So basically, she is advising against rash decisions and advocating tempered and cautious decision making. Ghana is not the EU, and our systems do not comply with the hard and fast differentiations that environment provides. Thank you very much for that. So with that, we move on to Mr. Uche. I think I need to mention here that Mr. Uche, unlike probably the vast majority of us on this webinar, Mr. Uche is Nigerian. And as such, he brings a different experience to the entire AI conversation regarding data protection and emerging AI use cases. So, Mr. Uche, what are some of the examples of data protection laws and their alignment with emerging AI use cases in Nigeria or any other countries with which you've been familiarized over the duration of your profession? Hello, Mr. Uche. Hello, Mr. Uche. Hello, Mr. Uche.
I'm here. Can you hear me?
Good, I can hear you now. Good,
Okay.
good,
I
good.
was
Yeah,
trying to confirm whether you can hear me.
good.
Okay, all right. Greetings, everyone, and thank you very much, Mr. David. I want to be sure you're the one that did the introduction, and big greetings to all the colleagues on this call. The conversation so far has been very rich, and I am very happy to be part of this conversation. Before I go on, just by way of introduction, I'm also a lawyer. So I guess this may make other of my colleagues on the call happy. I'm your colleague. Yeah, I'm also a lawyer and I focus on data protection and AI governance. And currently I work as a researcher at the Cambridge Center for Alternative Finance. So yeah, when we talk about AI and AI use cases, I think it is first and foremost, it's important for us to, and by the way, thank you very much to the organizers of this program for inviting me. Yeah, when we talk about AI governance, it is also good for us to understand how the system works, what the system is all about, and why data protection is important. So the AI we hear about today has become a buzzword. It's actually, a friendlier way or a simple way of, rounding up what machine learning and deep learning does, or what we have now as large language models in the form of ChatGPT. So artificial intelligence is the use of machine learning techniques to use is the use of machine learning techniques to train AI systems, to train the AI architecture to make sense of data and to give intelligent output. So once AI systems like the large language models that we have in form of ChatGPT, etc., are deployed, it actually helps most humans to solve problems from research to anti-money laundering controls, counterterrorism, finance control, etc. So because of the usefulness of artificial intelligence, it has become embedded in several sectors of world economy. But before I go on, and it's also important for me to state that AI also has components. And there's an author that simplified this component into what is called the AI triad. The AI triad consists of data, algorithm, and compute. Algorithm is actually the rules that computer engineers actually write, to instruct the architecture on how to learn on the data. And once these rules are actually applied to this data, it goes through a pre-training stage before it gets to the training stage. This helps the system to correct some mistake, etc. So artificial intelligence systems consist of data, algorithm, and compute. Why this is important is because these are actually the pillars that inform policy levers. Because policy is not made in vacuum, it has to be made on something. And if data is an important part of the AI architecture, it then means that data protection acts, laws, etc. frameworks now becomes increasingly important. So in as much as data protection laws are not called AI laws, by default, they are AI laws. And as Vanessa earlier argued, most of the data protection laws we have across the world was designed to, most times is designed in such a way that it can also impede innovation. But I think most countries are wary because of AI, of AI and use of data, because we don't really build most of this AI infrastructure. The United States, for example, controls the world, the AI hardware supply chain. And then, of course, China, Taiwan, etc. also play a role in this ecosystem. But Africa is not actually represented. As a result, our use cases is reduced to a consumer continent. But however, this can change. But for it to change, we need to understand that AI is comprised of data, algorithm, and compute. So now, in training AI system, large amount of electricity is required. The electricity that was used to train large language models in the United States is about 10% of, 5% of the national grid. And America generates over 1 million megawatts. And then compare that to what is generated on the African continent, you see that our development capacity is very limited. But being that as it may, the best approach to ensuring that we have safe and responsible development and deployment is first to look at what really makes up AI. Then currently, in terms of use cases, as other speakers have said, AI is being used in finance. Anti-money laundering control, for example, AI is used in to verify, to carry out know your customer processes, and also it is used for counter-terrorism finance controls, because when you know the person that is sending the money, etc., you know where it's going to, you know who is receiving, and that requires data. And our data laws actually make some provisions that even contradict these anti-money laundering controls. So, for example, you need to seek consent at every point that you want to share data. But however, if you seek the consent of a criminal before you share his data to where he can be investigated, that can truncate anti-money laundering and counter-terrorism efforts. So as a result, while we think about regulation, like I think it was Vanessa said, we also have to look at the good side of relaxing this regulation and embracing innovation. But in doing that on the African continent, we need to revisit some of the things that existed before AI. Because AI actually is good at scaling what is already existing. So if there's inequality, it scales inequality. If there's development, it scales development. So AI is built on infrastructure, and this infrastructure is powered by other digital infrastructure, which the government has to put in place. And also, as we are going to regulate different AI use cases in finance, in public sector, etc., we also need to understand that there are some global standards that limit how much we can even regulate that we can apply data laws. So take, for example, in terms of data retention, you are not supposed to keep data for a long time. But however, the FATF, that's financial, the financial anti, the FATF. Let me not go complicate issues with trying to say it full. But it gives a provision that banks and financial institutions have to hold data for at least 5 years. So if they need that data, they can come back and make reference to it in order to reduce incidents of money laundering and also terrorism finance. So if you look at that, you now want to take a seat back and understand that there's got to be more collaboration between government agencies. And this is going to be critical in the course of regulating AI use. And overall, what we always have to have in mind is that some of the regulation that we are seeing today are not new. Some of the regulations we are seeing today are not new. Some of the things that we require of AI for it to be safe and for users to use it responsibly are not new. They are built on ethics that actually exist before artificial intelligence. And one of the ethics is data privacy. That's the reason why all of us on this call are wearing clothes, because we have the right to data privacy. And let us not forget, colleagues, our face, our bodies, etc., are biometrics. They are biodata. And this biodata can actually be used against us or in our favor. So as a result, the best way to approach AI deployment, use etc., is to ensure that first we understand the components of AI system, and then also with that understanding, it is from there we begin to understand whether there are gaps in terms of capacity, and also it is from there that we begin to understand what we can regulate. But for now, The most important thing, as Vanessa said, is to create nodes that bring the different stakeholders together for them to listen to each other. So at the end of the day, when data laws are passed, it does not contravene the implementation of AI policies. And the best way to go around it, maybe a better way to go around it, is to look at what is happening in other jurisdictions as well. For example, the United States prefer to release frameworks from the INST to guide different companies on what to do and what not to do. Because as we want to regulate, we also want to, empower citizens to, to innovate and, to make life better. So I will stop there for now.
Thank you very much, Mr. Uche, for those insightful revelations. So now I think we can move on to Desmond. Mr. Israel, how prepared are Ghanaian businesses, basically, especially SMEs and startups, to comply with the consent requirements when deploying AI systems? Already, Madam Akwete has made us aware that there is much need for flexibility and not hard, fast rules. And there is a lot of vulnerability when it comes to Ghanaian business ecosystems. So, how prepared will you say our business ecosystems, as regards SMEs and startups, are to comply with the consent requirements when deploying AI systems? Mr. Israel?
Hi, can you hear me?
Yes, I can hear you now. Good.
All right. Thank you very much. Thank you, Dave, for having me, and thank you for connecting on the call. Greetings to all colleagues on the panel. So yeah, the question looks like one that would have required some bit of research and statistics. But yeah, let me just use my interaction with some industry players by virtue of my compliance and legal work, and then also throw in a bit of research, and we can consider general knowledge. Of course, that's what we are here for. My simple answer is that the general space is pretty much modestly prepared, right? And I say so both from whether you are looking at it from the implementation of various technologies to do this, even the understanding, the appreciation of consent requirements. Indeed, for many, consent is just a checkbox. I call it the cosmetic checkbox. And I worked with the fintech as a compliance lead for a while, whilst I was also doing active legal practice and consulting. So I faced some of these things directly, and for the most part, engineers would design and develop products. They push them out to the market. And when you try to align to let them appreciate that these are not merely technical requirements, but then they are governance obligations. So you don't just look at the front-end wording of, do you consent that your data will be collected for this survey, blah, blah, blah. You have to look at it from, are we complying with the governance obligation of what consent is, right? And the Data Protection Act for me is pretty clear on these expectations of how lawful data processing is supposed to be engaged in. So pretty much you look at Section 20, for instance, it speaks about the consent. it speaks about the possibility that if consent doesn't exist, which I'll address later, if you have legal authorization, you could. If there is legitimate interest, you could also process data. And if there is some sort of statutory duty on you, you could also process data. So yes, modestly prepared because of some of these key issues, whether we understand the lawful justifications that applies to the data that we process. And whilst you proceed on innovation, you might also be thinking that can data privacy become what we call a competitive edge, right? So these are baselines that you need to have so you would even appreciate how you design developments of whether AI products or digital products within your environment. Because there's privacy by design within privacy engineering, where some of us with very technical skills plus the compliance skills would be pretty much designing these products, deploying these products, built with privacy in mind. So to get the privacy in there, you can actually put it as part of the engineering process, whether it's on your continuous development, continuous integration, whether it's on the design phase of the product itself, whether it's through the technical team trying to implement some of the compliance requirements. So I've been on a project called Policy by Design, where in fact, policy by design, policy by code, where we are trying to train engineers to sort of like convert some of these regulatory matters into how they design national products. Of course, that is not within country, so it's not something I can reference here, but work with some other countries where what we are building there is build capacity for people to understand how they can engineer these things into their systems. If you benchmark SMEs and startups, my honest position will be that we are between what I call low to uneven, right? So really not doing too much. We collect the data, we deploy whether low-end AI products or mid-level or mid-level AI products, depending on what sort of processing you are doing. So from chatbots all the way to AI products that are maybe deciding whether a convict should get a bail or whether a suspect in court should get a bail or something like that. The impact on the privacy rights of these people vary as you progress up the spectrum of what the AI product does, how it is deployed, and what the outcome is when it comes to the decisions that this particular AI product will do. So that's just the baseline. Now, consent, you have to see consent from the angle of genuine choice. And listen, the text in the law, they are not random texts, especially if you have time to study them, find the policy reasoning behind them, juxtapose them to other jurisdictions on how we came by what we have. Consent is driven by the fact that data protection itself, from our side of the world, is a human rights issue, right? So the key thing you are trying to address with consent, which is similar to Ghana and the European Union side of things, I'll not use the US where I've done a lot of work, but of course, I know the regime is not the same, so I'm not going to mix apples and oranges. Let's deal with EU and Ghana, where both threshold when it comes to data privacy or data protection and privacy or data privacy and protection, whichever one you take, is all aligned to the human rights of the person. Now, reduce that to our barest appreciation as maybe engineers or compliance persons or legal persons. Consent is about genuine choice and ongoing control. That's it. I appreciate all the challenges the AI ecosystem brings us. And so I'm not oblivious of that. But the foundation must be clear that when you speak of consent, then it's about genuine choice. So the question is, as a business, are you giving your customers genuine choice for you to be able to work with their data? And like I said, consent is not the only grounds for data processing. So let's also not mix that. Right. But hear me out at this point. We define data processing in our laws in such a manner that it supports what I call data privacy in continuum, right? So from collection to assembly of the data, modification and manipulation of the same data, potentially disseminating it, storing it, and even destruction. All this is defined in our regulation currently as data processing. Now, these are all components that goes with the development, deployment and implementation and use of artificial intelligence products. So I say hear me out, because the fact that you scrape the data online, which is public data in the sense, which do not really bring in the purview of the data protection law at that point, does not stop the privacy of the person, or if I'm allowed to use the phrase, does not freeze the privacy of the person when you move into manipulation, assembling of the data, and even disseminating it. So you have to design your system such that these sort of ongoing activities that you do, one way or the other, will take care of some key principles in consent. For instance, explicit opt-in. If that would make it better for us to have an affirmative, clear action, not an implied means of collecting the data, then it's good, because as part of your engineering, you can connect the use of the data. That is why the law also speaks about specification of purpose. And it speaks about further specification or further use in compliance with the earlier purpose of collection. There are ways to design these things for them to flow and make sure that you are getting value both from a regulatory point of view and from a business point of view. And organizations have done it, right? So this is not new to some of us. It is not a tall order. Yes, there are compliance challenges where some will come with a cost and all that, but we get to that bridge and we create adaptive regulation and adaptive enforcement to allow everybody to be compliant in reality, not on a checkbox sort of compliance. Another principle is an informed consent. Do you want the data subject, the user, you and I, the customer, to understand what you are collecting the information for, why you are going to assemble them? Are you going to share it with somebody else? How are you going to use it? All these things are, if you like, they are contracted to the automation process, which is artificial intelligence. But that's why you design them to look at how the module is dealing with some of these issues, right? And then, is it redrawable? Is it possible? My own study shows that the right to be forgotten is quite very difficult to implement with AI modules, because as we speak now, there's no literature supporting the deletion of data that AI has been trained on. If somebody has it on the call, I'm a very avid reader. Kindly share with me on the chat. I would pick it down, copy and update my knowledge. But up to this point, that's one of the challenges you would have. And then, of course, is the consent very granular, very specific enough for your consumers to use it? AI models are dealing with consent in a number of ways, actually 2 ways by which I have come in touch with. Is either the static consent, where they module a one-time consent into the parameters and make it simpler for compliance. It has its own challenges, but yes, that is a way you can get that consent. So since we are looking at preparedness and actually getting the job done, I thought I should bring it into the picture. Then there is what they call the dynamic and the progressive consent, and it goes with the ongoing process, right? So it evolves with how the AI capabilities also evolves. A new model comes out, new parameters are added, new output expectations are made, compliance requirements are changed. It's adaptive. It's literally AI learning how to do it, manage its own consent. But that also brings some few issues. Now, just to wrap up the challenges the ecosystem will have in terms of the Ghanaian business environment, and I can also tell you for a fact that out of about 18 banks where I have personally been in charge of training the board on AI governance, about 12 of them confirm on various various training calls and training sessions that they are deploying AI. And I've always asked them, without the governance framework, do you anticipate the risk? Now, those are some of the things that maybe we discuss as we go on. But as you deploy AI and you're trying to get consent out of it, data erasure will be a problem. It's one of the challenges. And I tell both clients and people I supervise that challenges are meant to be appreciated. You have to find a way to live with them and deal with them, right? Both from a regulatory perspective and from an industry implementer perspective. So data erasure, as we speak now, is a challenge to data that has been used to train AI. My right to be forgotten currently is very difficult to be implemented via a trained AI module. Transparency is a problem. Literally everybody here may reference me to black box. So we've seen other, if you like, reverse platforms that are helping us identify a bit of transparency here and there and do what they call the AI explainability or AIX. And then auditability. And I work in some policy projects. I would shelve it if it matters. I'll bring it up. But I work in policy projects where we identify direct impact on the livelihood of people just because AI missed it. And I'm not talking conjecture. People's life, people were actually going to be in jail because AI got it wrong. People were going to lose their job because AI got it wrong. These were live cases that we worked with when I was with the Center for AI and Digital Policy in Washington, D.C., doing AI policy and writing AI policies for governance. Now, so that's where I wrap up, and hopefully I get to discuss best practice or any other thing that somebody may be interested in. But thank you very much for having me and allowing me to share my thoughts. Thank you.
Thank you very much for that insightful narrative, Mr. Israel. So now I would want us to get back to Ms. Kofinti, if she's still on the line. Okay. She seems to have left us. So maybe Madam Akwete can help us with this. So Madam Akwete, in light of all that we've shared so far, where does the Data Protection Act, sorry about that, how well does it hold up to scrutiny in light of everything that we've discussed so far? Madam Akwete? She seems to have left us. If Dr. Arnold is online, perhaps he can help us with that. That's okay.
Hello?
Dr. Arnold, yeah, good.
Okay, we're having issues with I think the default has been set so we can't unmute ourselves. So you might have to just unmute each one of us anytime you want us to give some input.
Yeah.
No worries, but like I mentioned earlier, I'll keep this very brief. I think, yes, there are some gaps that need to be filled. We do need AI-specific clauses in our Data Protection Act. At a base, it holds up pretty well in upholding data subjects' rights. It does need to be expanded to cater to the more nuanced gaps or issues that AI has raised, particularly with generative AI, deepfakes, that sort of problem. But at a base, we have a pretty good legislation that we can work with. Ultimately, it protects the rights of data subjects. Like I mentioned earlier, we can do with some expansion for the protection of non-personal data and how that is processed. And just the remedies that are available to people once their information has been used in that way. I say that's knowing that there are other laws. Let me just preface. Again, the reason why I think that why we don't need to be too aggressive with our AI legislation is there are other laws. So for instance, even when it comes to the non-personal data which I've raised, we do have a Copyright Act, so like your IP rights can be protected in other ways. But just when it comes to the processing, that's an avenue that I think we can improve. We have a good base, and we just need to build on it with a very collaborative and forward-looking approach is what I would say. I saw someone mention in the chat, I was just looking at the comments, that yes, you are absolutely right. In the drafts for the new data protection bill, there are provisions being made to include biometrics. So it's things like that. It's just taking a very informed approach, looking at what the specific gaps are and addressing those specific things, as opposed to looking for an overall overarching harsh legislation that's going to be talking about, say, how the reporting obligations to be or this or that. And I raised that specific instance because again, making sure that our acts are relevant to our context, you have to really ask yourself, how many AI developers and deployers do we have who are building these systems from scratch, right? So some of the provisions in other legislations like the EU AI Act are aimed at those big corporations who actually build these large language models from scratch. In our context or in our experience, you see that these solutions, a lot of people are building upon the base solution that's provided. So maybe our regulation doesn't need to just yet. I know we are aiming to get to that stage where we build and match these big tech companies in other jurisdictions. But for now, let's not take the approach of just importing legislation that doesn't fit. So that's just what I wanted to add. I think our Data Protection Act does very well in protecting especially the personal data of individuals. It just needs a few more tweaks to address specific instances to make it more robust.
Thank you very much for that, Madam Akwete. I would like to come back to you, Mr. Israel. In light of the trajectory of the discussion, what would you say a legally compliant AI data pipeline looks like under the current Ghanaian legal structure? When a Ghanaian fintech, for example, uses mobile money transactions data to train an AI credit scoring model, have we violated, for example, the prevailing act's purpose limitation principle?
Right. Okay. So when you ask lawyers questions, they'll tell you it depends. So let me preface it by saying it depends, right? Okay, but on a more serious note, when you're looking at AI governance, and I have a paper behind a paid wall on the AI Journal and Regulation, which is published by Lexen in the European Union. And I've argued in that paper forcefully that our regime of AI governance does not just sit with the Data Protection Act. Indeed, I had mentioned that the Electronic Transactions Act gives some bit of context in terms of governance. Look at it from, I know that law is going to be modified or changed, but it's one of the laws that I have personally reviewed, worked with research on, and I revered it. Every student that sat in my class that studied that law under me would repeat that I've said that it's one of the best piece of technology legislation we ever passed. Now, in that law, we defined electronic agents. And our definition of electronic agent was so vast such that today an AI module fits that definition. And I throw it out there, anybody who wants to have that conversation on the side, wants to look at these provisions, should just let up, because I have a paper which has been peer reviewed on that. And the definition is, like I said, is so, if you like, succinct to the extent that even liability that comes out of AI modules, AI use, AI products, AI decisions can be captured, because we also define intent when it comes to automation decisions, right? And we define various levels of liability, including tortious liability and also criminal liability under the same Electronic Transactions Act. Then you come to the Data Protection Act, where we specifically want to deal with personal data. Again, the drafters of those laws, for me, were smart enough to make sure that the definition of personal data were both data attributes directly accustomed to the data subject and also any other attributes that we could put together to identify the data subject. So I have a different point of view when it comes to, did you collect the data? What did you use it for? Okay, I collected biometrics, so biometrics is not defined. No, again, as somebody who litigates, I can tell you that no law in Ghana will be interpreted in court to defeat the purpose of it. So if the collection of that data is, for instance, and for argument's sake, nothing specific, is biometric data, and the violation sits with that biometric data, the definition of data will not be interpreted such that it will exclude biometric data to the extent that that biometric data identifies a person, right? So we need to look at the modeling of how we are perceiving regulation. If you were to violate the rights of any person, data subject, who is a customer who has used the product, so you took their data for one purpose and then you process it for another purpose, what you would have done there, apart from the Data Protection Act, is also dealing with the human rights violation, right? Because the strength of our Data Protection Act is directly connected to Article 18.2, which is a constitutional provision. And if you followed the Supreme Court recently, Goni versus Vodafone, we've been told that the evidence of determining these things will not be a liability on the data subject, and that the service provider would have to come and prove that they put their best foot forward. That's how Goni won his case. Otherwise, he wouldn't. He didn't win at the lower courts. He won at the Supreme Court. And the Supreme Court has given us direction when we are appearing before the courts, what we should look at when it comes to these, privacy, AI, technology related. Of course, they were not discussing AI, but we also interpret judgments as precedents. So you need to look at whether the outcome matches what the judgment has said, and then you proceed on that tangent. So we would have a situation where, as you're trying to, portray in your scenario to me, if data has been collected for one reason, and that's why I mentioned earlier that take note that data protection, data privacy, whichever one you call it, whether you put it together or you separate them, is in continuum. Collecting the, and there's a case, Clearview AI. This happened in the US. They didn't go to court because they settled. Now, they scrapped data from LinkedIn, used it in their system, did predictive analysis, and came out with different outputs. They were sued. Now, their defense was that they collected the data from online. I mean, I knew before the decision was coming out that my thought process skews towards data protection is a continuum. Go and answer that after you have collected this, which is lawful collection from the public, the processing of it, which involved your assembly of it, your data manipulation, your modification of it, and your dissemination also is lawful. So that's where you need to look at it. So I see where the question is going, but I think I wanted to provide a general education that would help whether business owners or lawyers or practitioners of the space to appreciate that you have a bigger responsibility in the face of regulations than just looking at it from a narrow view or a narrow perspective. And that's my opinion on this.
That's very insightful, Mr. Israel. Thank you very much for that. Now, I want to come back to you, Mr. Uche. So, Ghana's national AI strategy explicitly warns about dependence on foreign models trained on data that does not represent Ghana's context. Now, in light of that, what concrete steps, technical, legal, or institutional, should Ghana take to build AI sovereignty, including, regarding Ghanaian language models, locally governed data sets, and African compute infrastructure, basically? What knowledge does your wealth of experience bring to this?
Okay, thank you. I think that's a very critical question that everyone has to kind of, maybe along the line contribute to. That is a critical question. How can Ghana, ensure that the large language models that are used in Ghana actually, I think the problem with AI, specifically AI models, is the fact that, like the last speaker said, you don't actually know what to regulate sometimes. Because during the training process, most of the data is sourced from the internet. There's a lot of data scraping that is happening. So the question now is, what do you regulate? Is it what is used to train the system or what it brings out? And then if it is what it brings out, which I subscribe to, because like Vanessa earlier argued, if there's data in open source, in what we call public data, if there's data in open source, you can actually use it because the person that put it in the open source has given a universal consent, although that consent has limits. So it is the output now of the system that can now determine if the data has been, used, although lawfully collected, has been used unlawfully. So that this question now becomes very, very technical and critical. At what point? And I think the only thing that can be done is to increase capacity, increase development capacity. And on the continent already, there are some research groups that are trying to preserve African languages, using natural language processing. I think such efforts can actually help in a way that the data sets that these AI companies will use to train the pre-trained models are actually data sets that have been annotated by Africans. And specifically in the Ghanaian context, the Ghanaian government can actually can adopt a framework that, adopt a policy that creates a working group that will preserve Ghanaian languages, using natural language processing and ensure that these data sets are made available for AI companies that want to train their models to use, those data sets in order to ensure that context is not lost in the course of use. Another strategy would be for Ghana to generate more electricity, because for you to train model, you need electricity. So that is another critical thing. And then there's other different infrastructure. When you talk about algorithm, for example, that has a lot to do with talent. The Ghanaian government also maybe have to develop a policy that deliberately want to, build capacity. And I think that is in the AI strategy already. So implementation is very critical. Once that is done, I think that could be a significant way to respond to the issue of bias. And then when you talk about data sovereignty, that's another tricky one, because the deployment of AI systems is actually faster than governance itself. And like other colleagues have said on the call, most policymakers do not even really want to care. They do not really care about understanding these systems, and that is posing a big challenge, because if you don't know how AI systems work, you may find it challenging to make practical policies that can govern it. So that one, I would leave it hanging, that it is very challenging in terms of, because there are a lot of systems we are using, even the ChatGPT, etc. Most of those data, if the American government asks them to provide that data, most of them are banned by law to provide data for national security. And that's another issue that I think the Ghanaian government can consider. And these issues can be argued on in multilateral platforms like the UN, for example, the African Union, for example. I think those spaces, provide opportunities for the Ghanaian government, to make its voice heard. But practically, that would be very challenging.
Thank you very much, Mr. Uche. I see Madam Akwete has a hand up, so maybe she can come in again.
Hi, David. Yes, I had raised my hand when Desmond was making his submission. I just had a few points, and perhaps, Desmond, we need to take some time offline and really discuss this. But I just wanted to be clear and make sure I'm very keen on my submissions not being misunderstood, to say that our laws sort of don't cater to specific things. I think I'm rather trying to say the opposite. I think we have very robust legislation already in place, and so we don't need to rush to put more overarching laws in place. The reason I wanted to sort of come back on is, yes, I completely understand your point about how the current definitions of personal data, etc., can be interpreted or are so broad that when it comes down to it, we can get a decision from courts and we can have the legislation interpreted. Again, I want to raise that the specific foundation for this discussion is what are the gaps that we see in the current laws that we have. So yes, I think when you push them to their limits, much like the Copyright Act, right, that wasn't drafted to talk about AI. But to this day, when you go to court, it can be interpreted to sort of cover the necessary provisions to, hello?
Madam Akwete,
Yeah.
hello.
Can you hear me? Hello? Sorry, can everyone hear me, or is it just David? I see a thumbs up. I think that means you can hear me. Anyways, fantastic, more thumbs up. So Desmond, I just wanted to be very clear. I think the gaps that I'm raising is that our laws can be clearer, right? So when it comes to things like biometrics, yes, the definition of personal data now, because biometrics constitute something which you can identify the individual now, yes, it does absolutely tackle that point. But the whole reason why we have to go to court is because the law right now, as it stands, is unclear, right? It didn't anticipate certain uses. So I do think our laws could use with a bit of clarity. That is not to say that I don't think that they already protect the rights, because as most people know, I'm a big advocate. I say all the time, we already have the laws that deal with the major issues, be it in data protection and the copyright and the IP under the Electronic Transactions Act, like you've mentioned. In fact, if you look at the section on legal and regulatory compliance under the AI Practitioners Act, which we contributed to, I personally wrote some of the sections. That's exactly the point that we're making, that we do have the laws, so we don't need to rush and implement more legislation. But I was very keen on that point, not to get misunderstood, and that's what I wanted to clarify. Thank you very much.
All right, Madam Akwete, thank you very much for that clarification. Now I want to come back to you, Mr. Israel. So the draft protection bill, that is from 2025, that is looking to replace Act 843, introduces mandatory data localization for some sensitive categories. So we have biometric, we have health, we have voter, and then we have children's data. These all require reasonable efforts to store data in Ghana. That is on the part of, would you say this is an effective data sovereignty measure, or an innovation inhibiting trade barrier, particularly for AI companies and entrepreneurs that need to train on large, cross-border data sets?
Okay. All right. So I'm not a big fan of data sovereignty, data localization, I think, but I understand the space enough to appreciate why we would have provisions like that, and more specifically, when you connected it to the sort of, if you like, data sets that the regulation seeks to match this with. But if you look at data localization itself, there is the focal point of data localization is control. So the first question you ask yourself is, would you have control if, for instance, the data center sits in Ghana, but then an AI module that is being used on that data center subsume the data from another cloud processing platform or compute system, uses it there, trains it, and another module learns from that module, or a sub-module learns from that module, and that sub-module is sitting in another jurisdiction. By these examples, I've given you 3 different jurisdictions. So I have to see, I looked at the draft bill, okay? But I have to see it in this final form. Also, I would appreciate maybe if I get the opportunity to read the preamble, which usually explains what the regulator was thinking and what the lawmaker was thinking when they make those provisions. And then that would help a proper future appreciation of it. Now, you notice I'm very careful trying to address these issues because, like I said, first of all, I'm not a fan of data localization, but that doesn't mean that if it is required for very good reasons, it should not be implemented. That's why I'm discussing where you could also have data localization being defeated because of how technology is modeled. So, for instance, if you look at the sovereign cloud provision between Microsoft and France and Germany as an example, I think France runs the blue cloud. The laws that governs the data in the sovereign cloud is France's law, the same for Germany in their case. But then the sovereign cloud is sitting with Microsoft, and the data, the compute power are dispersed and distributed. I know a lot of some very serious technology people on this call, so I know they appreciate where I'm coming from with this submission. So in that context, Germany's concern is not where the data sits per se, because they may not have, if you like, the revenue, or is not part of the bigger budget to spend so much to host the data directly in Germany, but they want to control where that data goes, who uses it, who can get access to it. And of course, there's a bit of geopolitics in it, but let's shelve that for another day. So all I've said here is we can have the data localization regime as we have it there, trying to address some of these module training and all that. But it would take a very good enforcement direction or a proper interpretation to industry as to what sort of data localization we are trying to achieve. Because we can localize by technology, we can localize by platform, we can localize by location, specific location, as in the data must sit in Ghana. We can also localize by module. So what AI module is supposed to consume these data, so that the whoever is having such data has defined in law, and for which reason the regulator would enforce same, will not plug that data set on an AI module that has not been defined to include our areas of localization. Otherwise, it's defeated from the start before we even implement it. And so, again, there are so many permutations, maybe not so many, but there are permutations that we can use in enforcing data localization towards a data sovereignty regime, still balancing the innovation that other speakers have spoken about. And for somebody who also leverages on digital trade research, the question we should be also asking ourselves is, with such a provision, what happens to the Africa Continental Free Trade Digital Protocol provisions or sections of it that speaks of it speaks against data localization. So I call it the anti-data localization provisions in those international, if you like, continental context. So I love the question, but again, these are all questions that are always answered with context, because we are dealing with so many things. And I try hard to avoid my personal prejudices to come ahead of me in addressing these questions, because like I said, I'm not a fan of data localization, but that does not mean when a country needs to move towards a certain step, we should not be able to do that. I also don't practice my expertise like that. So yeah, thank you.
All right, thank you very much, Mr. Israel. So now we would want to go to the audience, and then if anyone has any question they would like to through to our speakers, but we are not doing too well on time, so let's try to keep it very brief. We cannot do more than 3 questions. Thank you. Any questions?
Yeah, I do have a question. Hello.
Yeah, Jen.
Yeah, hi everyone. My question is to Mr. Desmond. My name is Jennifer. I agree with the point on data localization, and I think that sorry, I'm just saying my opinion before I come in with my question. I think that generally you have to.
Jen, we have to keep it brief. So if you could go straight to the
fair
question.
enough.
Yeah.
Fair enough. What do you think about certain service offerings where you are allowed to choose where you're hosting your data? So for example, if Microsoft 365 has data centers across the globe, and so based on your location in your admin profile, you're able to choose, is that a viable option for government in terms of data localization restrictions?
Right. It's a viable option for good compliance and good governance. If you extend it to government, then you have to address a geopolitical issue, which I know is out scope from this conversation. Maybe on the sidelines, I can stretch it further. Because when government says he wants data localization, he doesn't want the personal data of his citizens to end up in the wrong hands. So if government says that, okay, as part of our data localization regime, data can be kept within the European Union, then it will suffice for the question that you are asking, of the opinion that you are seeking, which means that when you store data within the European Union, government is okay. But would you address the issue of control? And that control is not just you. We are talking government control. For the most part, data localization is driven by national security. So there is always a friction between liberal trade, human rights, and then the national security and protection of citizens, where states make these decisions of data localization or data sovereignty based on some of these, if you like, standard modules of appreciation. So yes, it looks fancy on the face of it that, oh, what if we choose a location as part of our data localization? I would then ask, have you addressed the control? Because that's what data localization is about. If government has control over these so-called server options or storage options in different locations, like you might have on AWS or Microsoft 365, like you're saying, then yes, the answer would be a simple yes. But you and I will have difficulty answering that question where government is still interested in the control. The data indeed sits in the European Union, but government doesn't have control. There is a reason why Schrems II led the abrogation of the safe harbor provisions in the United States, because the law called FISA in the United States allows the US government to get data of anybody from any US of any US company wherever they are in the world. And it only takes an ex parte motion before the FISA court in the United States. The European Union will have none of that. So food for thought, just run it around. But like I said, if you have the need to have a conversation, we can always do that.
Thank you very much, Mr. Israel. In the absence of any further questions, I think it has been a really riveting conversation, and the insights have been invaluable. Obviously, the time constraints did not allow us to delve as much into the conversation as we would have wanted. There will definitely be another opportunity for us to explore all these topics further. In the absence of any other comment, I would like to thank the AI Collective Ghana chapter and Knowledge Innovations for putting this webinar together. And I also like to thank our brilliant speakers for their invaluable contributions. We also want to thank everyone who logged on to make the discussion interesting and the event successful. With no further ado, I'd like to bring the webinar to a close and thank you all for being a part of it. So
Thank you
until
very much.
another event that allows us to explore the trajectory of AI, not just in Ghana, but across the globe, as we vie for our own AI and human agency. As Dr. Kavapo said in the opening remarks, it's goodbye from me. I've been your moderator, David Asante Darko. Bye for now.
Thank you and bye.